Jeg,
Viveka and I have divided this up between us, so I'm going to focus on the EU judgments here in this period. Now, the EU court are judging cases at the rate of knots, and I think they produce, I think, between 10 judgments a year on copyright, which means that during this period, 2015-2017, there are more EU cases and judgments that I can have the chance of speaking about here. So therefore, I have decided to focus on those that are cases of principle, if you like. Now, this is one case. This is from the EU court. They had to look at how, or to what extent, the loans of books, e-books, in libraries is consistent with EU law. You may remember the principle with regard to copyright in this case, that the rights holder has the right to for copies, but once he has sold a copy, for example, a book in a store, then it can be sold on, as it were, and then loaned. And when it comes to loans of books, the roles are in the loans directive, which state that the member states have to ensure that the rights holders have the right for loaning, but also that there's a consumption rules, which means that there's a public loan. And now in the Danish copyright law, the principle is the same. So it's only physical loans we're talking about, physical books at physical libraries that are included there. And the Danish libraries, at least, have for many years now wanted to have rules on e-books, and one can understand that. And I know that there are people here from the library world here, so this is important, I know. And unfortunately, you can't. I mean, it's been a problem loaning e-books. So here's the judgment then. The court then submitted its judgment in relation to the loans directive, so that if a state have the rules which make it possible to loan e-books without asking the rights holder, and many rights holder were against this, and this case was then looked at, and the court said, yes, it is okay in relation to the directive. And according to the court, and according to the directive, it also includes digital books, and on the, for example, library servers. If you, as a loan taker, if you have a limited download, and you can't loan pirate copies either. I think that most of the library world shouted for joy when they looked at this court. But the question is, what does this mean, really? Have we got a question already?
Kan vi få en mikrofon?
Can we have a microphone? There's a question already. I would like to ask. No, Nikki. Nikki would like to. Nikki with the blue tie.
Kan vi få tændt mikrofonen?
Please take the microphone. Speak into the microphone.
Jeg er sikker på, at Nikkis svar er ved at vente på.
We're waiting for Nikki to put the microphone on.
Er det ikke muligt at få lyd på ham?
Can't you get any sound for him, please?
Nikki, kanskje vi kan stikke op og Så er den der.
Hvad siger Nico? Er du ved at ændre på?
So paragraph 9, are you happy about this? That the libraries can... Well, yes, I understand what you're saying there. You want to have a response from me, but as what happened then was that the Minister of Culture had to in the Committee for Culture, was a call to the Committee for Culture, and there the Minister for Culture was asked, what is he going to do? And the response from the Minister for Culture was that now we have to wait and see what happens and see if the parties can try to find a solution to this challenge themselves, and they'll be given funding for that. And if they can't do something within a year, then the Minister for Culture has to look at this again and try to to see what needs to be in place, new legislation, etc. And I think that you're really showing what, I mean, in the Nordic countries with our licensing systems, we are able to resolve problems in relation to libraries, for example, without rules or without statutory rules, because you can only have an extended collective license for library loans, which also means that we don't have to create new legislation, perhaps, and I think that your response reflects that. So I don't think that this judgment is going to have any huge impact on the library world in the Nordic countries, but perhaps more on our agreements, which take the authors' interests, etc., needs into account. Another important case here is this judgment here, the GS Media case. It's with regard to public linking on the internet vis-à-vis the general public. This is something that the EU court had already dealt with in two previous cases. Svensson case, for example, you may remember the EU court said in that case that if you link to something that was freely available on the internet and which had been placed there with the agreement of the copyright holder, then that was okay. But it was unclear what would happen if someone was illegally or not authorized, as it were, to be on the internet. And it's fairly logical to think that you shouldn't be able to link if it's illegally available on the illegal material on the internet. But the judgment showed that not always the logic isn't always right, but one should have understood this. I mean that this would be the case. However, linking to illegal material is regarded as transmission if that it's only illegal if you know that this material is illegal. But if you link to illegal material but believe that it is legal, then it is not linking. And then the court also says that commercial links do this to make money, for example. I might understand that the material is illegal. Well, you might wonder about people's knowledge, etc., that should have an impact in this particular area or not. But the court has already said in previous cases that has already discussed the idea of the knowledge of the general public. And we also know this from other cases in Nordic cases. Knopf, for example, we see there that if a singer practice singing with an open window, and is that a performance? But it depends on the aim of the performance, if you like. And if you, for example, rent cars as a car hire company with a radio. I mean, there again, that's also a different, what we call the Knopf criteria. And I think that this is made clear. And here we can see another slide, another case, the sort of general EU legal criteria. The question of whether, I mean, when a performance or when people are elsewhere other than where the performer is, whether this is EU harmonized or not. And the question is when a transmission is made to the general public. And the EU court has said that a transmission geared towards the general public based on these issues. I mean, firstly, the transmission is to a large number of receivers, and the court then calls it cumulative. This is a new thing. So that if you firstly have works once, and then you transmit it once, and then you retransmit it, and then you retransmit it again and again, then you can add all these retransmissions together. So even if they're private, then together they become public. Cumulative. And moreover, the court has also said that it should be done deliberately and for a new audience as well, that the rights holder, new audience is also relevant when you have renewed transmission, when, for example, you retransmit something that others have started, for example, cable TV or radios, radio playing in public spaces. And the EU court says that if it reaches a new audience, i.e. that the rights holder in his head has not presumed that this audience, this new audience, would listen or would see the works. And the EU court has also decided that what's important is whether it's for commercial purposes or not. And this is important. This would change, in fact, legal practice that has been in place in the Nordic countries for the last 100 years. And there's as you may know, the Danish case with regard to youth clubs and playing music for free in youth clubs, for example. The clubs, I mean, this is for a service. This was being overruled then with this. And I hope that Dakota and Gudmundsson will be sending their bills to these youth clubs, because and that this is private because these clubs are alternatives to being at home, so that won't apply anymore. Or do you know the Danish case on innovation activities, which let many people to have access to places where they could listen to music, but the Danish court said that there were more than 40 people in the room, then it wasn't public. There weren't more than 40 people in the room, then it wasn't public. This has been overruled. So we have now these new EU cases which will have an impact, obviously, on these previous Danish cases. And I'm proud to say that these are there's an article being written on this, and it's really the most complicated and complex article that's ever been written, I would say. And there's a sort of list of contents at the beginning of the article, really. And we see that the world has never seen anything like it. And the article ends with the point of view that the EU court basically has overruled the Nordic understanding of the general public. And so this rehab training case is important because what it does is that it rules that what is also, when you look at the term the general public, and you may remember that the court already looked at this, touched upon this in the Tande case, the dentist case, because he had a radio on in his clinic. And the EU court said he didn't have to pay to the rights holder because you don't go to the dentist to listen to music. And it was a bit doubtful whether this was only applicable to the authors or to transmitters, but the court then went in many curious ways. The rehab training case, there the court decided that this is with regard to all forms of transmission to the general public, even vis-à-vis the rights holders. So they over-rationalize, if you like, the situation. And this is an advantage from the rights perspective. And I think that the EU criteria now are better than the Nordic criteria because, I mean, for the Nordics, I mean, there we had the article that was so long. After the EU legal, I mean, there's only a few. And I think that these are very clear criteria. Now, let me also add that when we talk about the criteria of general EU criteria, and there are certain which are difficult from a theoretical and practical point of view, and that's the new criteria with regard to the public. And this is that when it comes to retransmitting something that somebody else has already started, when you come to cable transmissions, as an example, or a radio, for example, in a store, then the transmission reaches a new public or a new audience that the rights holder hadn't had in mind. But this is very tricky.
And what I'm trying to say here is that when it comes to the audience, they're considering audience 1, but not audience 2. It's sort of a quasi-psychological claim. Professor Jan Rosén wrote about this in the Swedish Legal Review, looking at a number. This is for the jubilatory publication for Professor Rosén, where this was commented upon, and an external voice said that there could be opportunities where performance number 2 took place with the same technical means as the first performance. And as a result, if you looked at the court, a broadcast using antenna, and which is now available on the internet, while it was being watched, the rights holder would receive compensation whether or not they could have predicted that this would have been a new way of making this public, and it was performed using the same technical means as the first performance. But the court has also come back to that, and I will refer back to it in a couple of slides. This one is a central ruling. Collective management of electronic book rights. There were some provisions in France for books that had been published before 2001, which were no longer commercially distributed by the publishers, and so were no longer made available. And these French provisions stated that when such expiring books have been on a database for 6 months, they may be digitized with payment to the Minister of Culture and with representatives of authors and publishers, and under certain conditions, if there were rights concerned, then this could be resolved in such a manner that the court had to rule on whether or not this was acceptable. And they said no, and they referred to provisions in Article 5 and said that the authors had not consented and their views had not been taken into account. And I'm mentioning this because it's sort of reminiscent of what we've come across. It gives some very unpleasant associations in connection to the Nordic agreement traditions, rather unpleasant questions on what we're going to do. I'd like to ask my colleague if we can have a microphone on this perspective on it. Otherwise, perhaps we have to have a look at the time available. But I'm wondering, in text and music, text and author, how do you perceive your future when it comes to digitization? He's sitting over there, if we can ask him. Anders Christian Reich, my friend. My friend, Mr. Rosenmeier, I don't think we should think about the time, because I really need to point out that the French provisions are very different than the ECL provisions in the Nordic countries. I don't think there's every reason to worry about that. But there are some points in the Soulier ruling which could be difficult. That's clear. Either it will be cleared up or things will be amended. There are some initiatives reported from the European Commission on the out-of-commerce provisions. But we believe that this is mainly based on the French provisions, and therefore it's not going to be relevant to us in the future. Thank you. Are there any other ones here who have an argument to make in favor or against this impacting the Nordic provisions? Perhaps at the back. Could we have the microphone back there? So Sunning, who's also there at the back, he's sitting over there. He might have a comment. Thank you very much. I agree totally with Anders. The Soulier ruling, as far as I'm concerned, is not a threat to the Nordic perception for many reasons, mainly because the ECL licenses have already been approved in the EU directive on copyright, which we're familiar with. There is a recital there which is relevant in the directive on copyright in the Information Society directive. And when it comes to the French setup that you've described is different. It's lacking some of the elements which are most significant for our situation, in particular the extended license. It's not a matter of extending a license or transferring rights to anyone without having a collective license. So to me, it's quite clear that the Soulier ruling is not a risk or a threat. But when it comes to the Advocate General, if we look at the statement provided, we see that the ECL isn't mentioned as such. If the Court of Justice in Luxembourg felt that this was also relevant and pertaining to ECLs, they would have mentioned them in their ruling. And because it wasn't mentioned, this is a clear indication to suggest that this specifically a ruling on the French set of rules and this particular Soulier case. I can agree with you on that. And so firstly, in the Soulier ruling, you can the court emphasizes that this is not the Infosoc Directive, Article 5, but there are lots of Nordic ECLs that are covered there. And they also say that you need to take into account the authors. In Denmark, the copyright holders, if they have an ECL, can, according to various paragraphs, be covered in that manner. And as you can see here, I'm going to tell you about one more ruling. If you're at peace, having heard the rulings on the Soulier, in the Soulier case, here is another one that might be some cause for concern. As we have talked about, a basic assumption is that we need to look into renewed performances. If somebody performs a production with the approval and then somebody else performs the same thing, we need to also look into whether or not remuneration is to be paid. But we have rules on cable retransmission, for example. A TV broadcasting company or a radio symphony might broadcast, and then a cable company would capture the signal and then broadcast via cable. That should be liable for remuneration to the rights holders, because this is an independent new performance of that particular production, and according to which criteria should you pay. And here the court has tended to say that a new audience criteria is not relevant if the performance is performed by way of new technical means. So, to my knowledge, there are this was with a limited number of judges, and in this ruling, there's a mention of a case where if in a national broadcast of TV or radio, it is not a performance or transferred to the general public if a new medium or new channel should transfer that. I hope that you realize that it's very important to come here. If a television signal is sent out via the television network and a cable network resends it, we won't get a billion, or we won't get anything if it's retransmitted under these circumstances. Mikael Waldorf, could you tell us your views on this? What are you thinking about this? How is this going to impact? There's so much money involved, in fact. Mikael Waldorf was sitting there. Perhaps we could get him the microphone. I'm not sure that these women understand Danish as well as the rest of you do. That could be the reason why the microphone is taking its time. Would you do this in English? Well, there's translation machines, says the speaker. Well, this has been discussed in television of the world. There are various risks indeed, which means that you might argue and say that the right holders might sign an agreement with the a symphony, say in Austria, and that they understand that there will be a retransmission. If you want a more legal analysis, I have to say that you need to ask Mikael Rowan. Mikael, where are you? I'd be very happy to hear, because we're talking about billions of kroner here if all these rules. He's my old specialist student. In fact, let's see what he has to say.
Som Michael Waldorf helt rigtigt siger, så...
As Mikael Waldorf is pointing out, you can only read this in light of previous precedents and look at how they're arguing here. They have a very clear practice in this term, in these terms, but we will need to look into it more closely. What's worrying us is the fact that the EU court has opted for the solution that they chose in this case, with relatively few points. They've made their ruling, and it's impacting their entire perception of new audience, and that it is a fixed practice that they're mentioning the concept of new technology either or new audience. It's an extensive ruling in the sense that they're referring to all the previous rulings on new audience, with the exception of one which isn't mentioned at all. Okay. So as far as I'm concerned, to say when you're talking about these three rulings when it comes to AKM, the work of those are sort of pushed into the large chamber. There was also an Italian ruling previously where subsequently the court enshrined a practice that will have consequences in reality. So the question is whether this is a completely separate national ruling. Well, there's also the point that they immediately consented in the country to retransmission via cable. Many rights holder in Denmark would have that as a special clause in their contracts, which doesn't give an immediate consent. Thank you very much. I was wondering if there's anyone who would like to make a comment or as a question. Professor Blomqvist would like the microphone, please.
Heldigvis til at få øje på.
He's the one I happened to spot just now. Thank you. I think that from a Nordic perspective, I really think we should consider starting to work on the concept of new audience being changed in a new directive, so using the legislative path. The EU court has used as source of law a guide which had been produced for developing countries. So they're taking another provision, using it for their interpretative purposes, and they're using it as a rule, as a provision, and they've then draw their conclusions. This is a methodology that the Vienna Convention, the Vienna Convention has its perception, and if you look at this methodologically, we have the matter of time, but it also has to be logical. We need to define the concept of a public. What is the public? And who can be included in this group, the public, the audience? In the way we define that will impact also what the provision contains. The user provision, thinking that when you sign agreements on rights, You're simply are providing a circular provision which is taking you around, and it's the court who decides what the rule should be. It doesn't matter what it says in legal provisions or directives or similar. That's absolute madness, and we simply can't accept the argument that they've chosen in a state of and with rule of law. We need to do it. I think we, the Nordic countries, need to use the legislative path to try and resolve this so that we can get a solution. Thank you very much.